Good afternoon. My name is Petra Desitova, and it is my great pleasure to welcome you all to our first online event, jointly hosted by the Nordic Institute of Asian Studies and the New York Southeast Asian Network. Today's event is an official book launch for the recently published title, Fighting for Virtue, Justice and Politics in Thailand, written by Professor Duncan McCargo and published by Cornell University Press. As many of you might know, Duncan McCargo is Director of the Nordic Institute of Asian Studies and Professor of Political Science at the University of Copenhagen. He's best known for his writing on the politics of Thailand, most of which is grounded in detailed ethnographic fieldwork. He is the author of a number of previous books, including Tearing Apart the Land, Islam and Legitimacy in Southern Thailand, which won the inaugural Bernard Schwartz Book Prize from the Asia Society in 2009. Over the next hour, Duncan will introduce his latest book, Fighting for Virtue, in conversation with two distinguished scholars who have done extensive research on the Thai justice system themselves. Tyrell Haberkorn, who is an Associate Professor of Southeast Asian Studies at the University of Wisconsin Madison. Tyrell's work straddles the realms of history, anthropology, and politics. As one of the world's foremost scholars of Thailand, she is highly regarded for her critical writings in interrogating issues of state violence, justice, and impunity. Her latest book is titled In Plain Sight, Impunity and Human Rights in Thailand and published by University of Wisconsin. Frank Munger is a professor at New York Law School with interest in public law and human rights. A sociologist by training, he is a former president of the Law and Society Association and has published widely on poverty, labor issues, and disability. In recent years, Frank has been conducting a major project on cause lawyers and the human rights movement in Thailand, where he has conducted extensive fieldwork on the work of human trafficking NGOs and other issues. Now, before I hand over to Duncan, I would like to invite the audience to send us your questions via the Zoom chat function throughout the event. Towards the end, I will make a selection of questions to ask our distinguished speakers. So the floor is yours, Duncan.
Thanks very much, Petra. It's a wonderful opportunity to be able to have a chance to talk about this new book. We have been hoping to do a book launch at the Thailand Update Conference that we usually have annually at Columbia University, and we should have done this about a month ago with Frank and Tyrell present. Unfortunately, that hasn't worked out exactly as we'd planned because we've been hit by this pandemic problem and we're no longer able to meet in person in New York or anywhere else, alas. I'd also hoped that we'd do a later event that would take place here in Copenhagen. So we sort of merged two events into one, probably a March and a May event into this April event. It is one of my favorite days of the year, by the way. It's Shakespeare's birthday, so the choice of the 23rd of April is not entirely coincidental at this point. So what can I tell you about the book? We're going to hear much more sensible things about the book from two people who know a lot about these topics and have been working on them for a number of years too. But let me say a few things about the book. This is actually it. This is the physical copy. It really exists, Fighting for Virtue. It's actually at the moment the only copy I have, so it's a rare commodity. It's a huge pleasure to get hold of this book, as I finally did a few weeks ago, and to be able to sort of think about it as a project that's been finished, because this has been something of a trial, a bit of play on words there. It's been a challenging project for me to complete. I have been working on it for quite a number of years, and at certain points I wondered whether I was ever really going to get it done. So why has it been such a challenge to write about this topic and to complete this book? The challenge, I think, has to do with a number of things. First of all, I became interested in the question of politics and justice in Thailand a number of years ago because it seemed to me to be one of the most salient issues that went to the heart of what had been going on. We had those two royal speeches in April 2006, a whole discourse that emerged about so-called judicialization, judges being told that they were supposed to help solve Thailand's political problems and interpreting that in a variety of ways. And since then, we've seen a very large number of court cases, both constitutional court cases and regular criminal court cases that have involved different aspects of the political system and the justice system going head to head, as it were. So there's been a lot of it about, and the more I dug into it, the more I realized this book is about everything that's going on. You can't really easily delimit the nature of the project because it's such an extensive and all-embracing topic. So you really come up against a lot of different issues. And I found myself caught up in, I spent a year in Thailand in 2012, attended a lot of court cases, and was able to gather all kinds of material. But when I came to sit down and really try to write it up, I felt like I was swimming in mud, trying to get to the bottom of what was really going on here, what was the pattern, what was the cause and effect, what was the core issue. So the book is an exploration of a number of things. It's primarily driven, like a couple of my other books, it's driven by ethnography and spending a whole year immersed in certain kinds of studies, spending a lot of time in courtrooms, spending a lot of time hanging around, having conversations with people. The cases that I was following were mainly of two kinds. They were cases that you might broadly term freedom of expression and participation type cases, human rights related cases in the criminal courts. And then there were another range of cases in the constitutional court that involved sort of direct challenges to political parties and the status of politicians and so forth. So a couple of different kinds of cases were involved in the project. At the end of it, what is it that I'm arguing? Quite difficult to sum up, but what I'm really trying to deal with in the book is what I call a culture of legalism, a belief that you can solve the political problems of a country, a very complicated country like Thailand's, by engineering certain kinds of legal and political mechanisms, constitutional interventions, mandating judges to carry out certain sorts of functions that are really effectively political functions and expecting them to solve various kinds of problems. And I'm critical of this whole discourse and idea of legalism, which goes far beyond simply what we're experiencing in the context of Thailand. I think this is a much broader set of questions. I've written elsewhere about my critiques of transitional justice as a problematic set of assumptions about how issues can be dealt with. So I see what I've done partly as an in-depth study of Thailand, but it's also a study that speaks to larger questions and discourses about what's going on in terms of justice and politics. Quite coincidentally, while my book was in the process of being published, this book came out. This is, for those of you who don't know it, Jonathan Sumption's Trials of the State. He's a former Supreme Court Justice in Britain, and he argues in his Reith lectures, BBC lectures of last year, that you could identify parallel kinds of problems in the British system where there's a kind of structural contradiction between what is the political and what is the legal. Now, it's clear that someone like Jonathan Sumption and quite a few other people who might seem to have a similar position to me have actually a very conservative understanding of politics, which doesn't correspond to mine. They're coming at it from a different, perhaps ideological lens. But I find myself to some extent in agreement with those who argue that we can't continue to assume that better laws or better courts or better judges or other sorts of mechanisms can really effectively regulate a political system. Thailand has so much regulation of its political system in legal terms, and yet it's been, despite all the talk about peace and order, it's been one of the most unstable countries in the world over the past 15 years. We have sort of lost count of the street protests, elections, constitutions, military coups, legal interventions, so on that have taken place. So all this stuff hasn't really worked in the Thai case, and that's really what I've been trying to get at. In trying to get at it, I attempted to enter into the imaginative world of judges, which is something I'm not sure I've ever really been able to do successfully, but that was, to me, one of the most interesting parts. who are Thai judges and how do they think? I still don't really know. I've written 3 chapters sort of explaining why I don't really know. And that discussion about judges and who they are and where the judicial and legal mentality in Thailand comes from is one that informs my discussion of the cases and the overall conceptual framing of the book. So that's it in a nutshell. It's very hard to summarize. Not many people will really want to read it from cover to cover because it's quite long. But I would love people to order it. You can order it from the Cornell University Press website or from a certain legendary online bookseller that I don't wish to name and proselytize for in this format. But you can also, of course, buy e-versions of the book, which are probably easier to access during the very strange conditions that we're operating in during this pandemic. I hope some people will read some parts of it and find things that will interest them. To me, the most interesting chapters might be the early ones where I talk about the judges, and then when you get into the nitty-gritty of the court cases, some will find that more fascinating than others. So that's the book. I spent a long time on it. I kept thinking I would do a follow-up book. I'm not sure whether there will be a follow-up book. There's some follow-up articles on the way. So yeah, that was my life for several years. That's the book. And now I'd love to hear from a couple of people who understand these issues much better than I do about what the book got them thinking about, whether they want to react to the book itself or to raise other issues that relate to questions of justice and politics in Thailand.
Thank you, Duncan. So now the floor is over to Tyrell and Frank.
And Tyrell first.
Okay. So thank you. So I'm very excited to be part of this this online event. And I just wanted to start by borrowing a phrase from Mona Eltahawy, the feminist writer, and say, I send care and solidarity to everyone. I hope everyone who's listening, beyond your interest in thinking critically about law, that you and everyone you love are safe and will continue to be safe. And I want to start by saying that, Duncan just said that maybe people shouldn't read it or wouldn't read it cover to cover. I want to say to everyone, do read it cover to cover. There's a tremendous amount of rich analysis and ethnography in the book that is, I would urge people to read. What I was struck by so many different things in this book and think that there's a lot for us to think about. So I want to talk a little bit about what I think the key questions are that are raised, and then by the book, and then offer 3 questions that I have about or coming out of the book, and then end by saying where I think the book might leave us in terms of a hopeful look forward, if that is possible. And I say this because as Duncan writes in the book, you conducted, it's hard to know, do you use the 3rd person or the 2nd person here, conducted the bulk of the field work in 2012. And at that time, the crisis of justice or injustice that had been building since the 19 September 2006 coup seemed like it was reaching its peak, looking around. Now, 8 years later, that was just one, as it turns out, of many different kinds of peaks. And I think the comparative, I would urge, even if there are people listening who are not interested in Thailand specifically, I would make the argument that you should read this book too, all of the non-Thailand folks in the room, largely because I think the crisis around justice and the role of courts and the role of law in public life is growing everywhere. Certainly in the UK, certainly in the US, where I'm sitting right now, it is really clear. So what are the key questions in the book, and what is the argument that is being made? And I want to take this from the preface, because I think it's a beautifully articulated explanation of the project of the book. So Duncan, you write, quote, "Why did the Thai courts embark on a path of judicialization variously defined from 2006 onward? How did they rise to the challenge? And above all, why did they fail? My tentative answers: judges failed partly because the mission they were given by the king was an impossible one, and because the monarchical network could never decide what to do about Thaksin and his associates. Judicial crackdowns, evasions, and procrastinations reflected the inconsistent position of the palace. But judges also failed because they took their nominal role as royal servants far too literally, trying too hard to protect the fading monarchy rather than to administer justice in the public interest. I found this to be such an important and evocative place to start the book off, precisely because I think too often judges are viewed as all-knowing and as impenetrable. And I wonder if that's precisely a function of what you trace in the book, that it's so hard to access what they actually think. And I think trying to figure out what we take from that analytically is really important. And so actually simply thinking about judges as people who make mistakes and who made mistakes is, one, incredibly important, and also it's a radical position to take. So to turn to my three questions, what I have spent the most time thinking about in relation to this book, and in fact, I would say in relation to much of your writing on the judicial system, is related to this critique of legalism. Is the problem the legal system, the law qua law, as a solution? Or is another way to think about it that the problem is the profound inequality that underlines every aspect of public life in Thailand? And also, how might these two problems come together? And so, again, to pull a wonderful quote out from what you write from page 18, you write that, quote, "A big difference is whereas the monarchy, military, and Buddhism are to some degree divisive, critical views of them exist. Legalism is a totalizing discourse. Even people who see themselves as progressive or liberal believe in legalism. They may be unhappy with the judiciary, for example, but they imagine legalism as the solution to Thailand's problems if it could simply be got right. If we had better laws, better recognition of human rights, a better constitution, a more activist and broad-minded judiciary, everything would be okay. The problem is not the legalism itself. It is the way Thailand does legalism. It is this belief that legalism is not the problem is we have the wrong legalism, that this book sets out to question." This is an enormous question, an enormous challenge, and it's one I have to say I don't think I agree with, but I find it very, very exciting to think about, and also just as to exhort people in the room to, if you haven't listened to or read Ajahn Hong Thai Winichagun's recent Ajahn Bui lecture on Rule of Thai, Bap Thai Thai. It raises a similar kind of question with a different kind of argument and strategy. But so I think, reading the two of them together is very productive. But I think if I understand your argument correctly here and elsewhere in the book, the idea is that the law is too often used in an attempt to solve political problems. And this raises this whole question of what is politics and what its relationship is to law, which I'll bracket for now. But the question that I would pose to you, what if the reason why legalism remains powerful for critics of the system, for progressive activists, for lawyers, isn't because they fail to recognize the problems with the law and the judicial system, but precisely because they choose to use it because of the violence present in the law and the judicial process. So I find myself wondering that, is it precisely because of the problems with the law and the judicial system that the solution has to be forged there? And in that sense, it's a different take. If we think of the poet Audre Lorde's wonderful phrase, "The master's tools will never dismantle the master's house," which I agreed with for many years, but in looking at the Thai justice system, I sometimes think that if her idea is completely wrong, and in fact, we have to use the master's tools to dismantle the master's house in order to show how shoddy the construction is, and also how slave and low-wage labor was used to create that very house. I mean, that's so I would love for you to talk more more about that. So the second question is this question of what is politics? And I think here you offer readers an excellent definition and a generative one in terms of how you describe and define political trials. And what I think is so fascinating is that this is a book both about the freedom of expression trials of Somyot, Khatta, and Adanjan, as well as the Thaksin-related legal cases. I think thinking about those two together, those two kinds of trials together, is really important. What I wonder is, so when you define political trials, you note about the freedom of expression cases, which you identify as second-tier political trials. You say that these are often more, quote, often more illuminating than the top-tier trials of leading protagonists. They were held in normal criminal courts by ordinary judges, and although the charges were unusual, the procedures followed were standard ones that applied to all criminal cases. I wonder if, in fact, those are the most important cases in terms of shaping what politics looks like and who can participate in it in the Thai polity. In other words, that where that's being worked out isn't in the trials that everyone pays attention to, isn't in the Thaksin and the political party trials. It's in the trials of ordinary people who are prosecuted for expression. So throw that out there. The third question I want to pose, and this is a little bit, I mean, I'm not sure if we'll be able to think about the answer, but what is the future of treason cases, the potential futures of treason cases under Rama X? Again, I think one of the important and powerful pieces of the book is your discussion of treason and of thinking about 112 and computer crimes cases as treason. Those that you examine in the book are quite different from those that may be emerging right now. And I think in particular of the recent arrest in February of Niranam, of Anonymous, the Twitter person. I was trying to think how do you identify Twitter activist, right. Who was arrested following a string of critical tweets on the history of Rama VIII. And I think what I find most troubling as an observer in this moment is not having any sense of what these kinds of cases might look like in the present. And so I would invite people to think about what is treason today. And I just want to end briefly by saying that it would be very easy to read this book and feel quite hopeless about the present, the recent past, and the future. But you give us a very suggestive way of thinking about what might be a different kind of future in your writing about liminality and tribunality. And what you write about is these unexpected moments where different figures active in the judicial process, in a sense, interrupt repressive legalism. So I wonder, where might that go? And what might it take for there to be more than just moments in which the existing order is questioned, to turn into something else, to turn into a different kind of politics, perhaps, where ordinary people stop being prosecuted for expression. So I will stop there.
Wow. Thanks so much, Tyrell. I mean, those are just fabulous comments, and now I have to go away and write another book just to answer them. I mean, there's an awful lot that I need to respond to there, and of course, in some of the passages in that book, I did have our many conversations on these subjects in mind. So, you know, when I'm writing about my critiques of legalism, I was imagining you actually reading, and it was very nice of you, you know, as a lapsed literature student to read some of my own words back to me and ask me to reflect upon them. That's an interesting situation to have. I like that mode of interrogation or examination very much. Yeah. Where do I start with all these comments? I can't do justice to all of them, but let me just try to say a few things in the time that we have. I mean, I became fascinated by Thai judges. Many of my Thai friends told me I was Thai in a former life, which is, to me, a rather far-fetched notion. But if I was Thai in a former life, maybe I was one of these Thai judges. I identify with something about the ethos of their work, that they're very dedicated to public service, that almost like monks, certainly in previous decades, they felt they had to remove themselves from society and live only in the society of other judges and their families, dedicate themselves to the nation and to doing good and fighting for virtue as they saw it. So I think that, I feel a lot of sympathy for judges, especially having sat in court cases which were unbelievably tedious, where many of the people in the room were behaving rather badly, including, as comes through in some of the discussion of the court cases. I think the defense lawyers were at times attempting to provoke the judges quite a lot. And so I do really, really sympathize with judges, and I tried very much to understand things from their point of view insofar as I could, which was not always easy. And I think that sort of links to your final point. And I got these ideas from Robert Ferguson's book about American trials, which I do think is one of the most wonderful books about law and politics ever written, for those who haven't read it. He talks about liminality and these moments. It's harder to achieve those moments in a Thai context because the system isn't very well geared up to create them. I also got this idea partly from a student of mine at Columbia who wrote a paper about effectively liminal moments in the Khmer Rouge tribunal, in the Doik case, the first case. And he said that even though the case itself might have been a farce and the decisions were not very satisfactory, there were these moments when people stood up and there was witness testimony and people talked about things that happened to them which were highly illuminating. So maybe that's something that you can take away. We could have flashes of luminosity even, if not liminality, that's another word I play with, and tribunality, which is making a kind of pragmatic decision. We're basically going to treat this person very leniently or something like that in order to be more sensible in our judgments and not stick rigidly to the code. So if it were possible, my dream is that a book like this could in some way help to influence some of those involved in the judicial system, so that even if they know they can't really change its fundamental, the inequalities that you mentioned are absolutely at the core of it, of course. Even if those fundamental inequalities are too big for individuals to change, individuals could try to create moments of luminosity, or liminality, or tribunality within the context of court cases that they're involved in. And that is a strange kind of message of hope. I agree it's a dark book, and it's one of my photographs on the cover. The photograph was actually taken in the daylight, but by the time they've done this wonderful design on the cover, it looks as though it's in the middle of the night and everything's been plunged into darkness. And it's a great cover on one level, but it also, I wish there's a little bit of gleaming white from some of the riot police helmets there. I wish that gleaming light could be a luminosity that could illuminate some of these trials. So yeah, the legalism question is a really big one. But if you believe, like I do, that essentially laws are just politics by other means, people have to accept the legitimacy of the political system instead of trying to come up with legal mechanisms to give the political system more legitimacy. So long, it's a bit like the coup problem. As long as the military can always intervene, then you never really institutionalize electoral politics. And you shift the terrain away. Okay, so military coups are passé, except they still take place. You then move on to a new terrain where, well, okay, what we're looking for is not a military coup, but a judicial intervention which will solve this problem and sort it out. Then you get one step further away from having confidence in a legitimate mode of electoral politics. And I feel very strongly that people just have to ride with the politicians and throw the politicians out at election time and not assume that there's some legal way of reining in the political process. But it's a debate which I'm sure we will talk about next time we meet, and it will run and run. What is politics? I have another article which I hope will come out fairly soon. I'm waiting for some feedback from the journal editor on it. I wrote up some of the ordinary trials that I went to in provincial courts that had nothing to do with freedom of expression or the Constitution or whatever at all. Theft cases, assault cases, defamation of a monk, extraordinary cases that really went to the heart of these inequalities. And I actually almost felt like the real politics was there. So much was about what kind of resources the defendants could deploy in order to defend themselves in a system that was really stacked against them. So I felt that there's so much politics going on at every level. I guess this is why I'm such a maverick political scientist, because I see politics absolutely everywhere. It's not constrained by, it doesn't have to be a case with a capital P word anywhere floating around in it for the case to be highly political, because even these, when I'm talking to the police officer guarding 2 drug dealers in a provincial court, and I say, shouldn't these 2 guys are facing death sentences potentially, shouldn't they have a lawyer? And he said, oh, poor people like this never need lawyers. And to me, that was just so resonant of what was going on here. That comment illuminated more than, would illuminate more than several hours sitting in the Constitutional Court. So those are some of my attempts to answer your questions. But, and of course, Judith Sklar is my source. Her book on legalism, this wonderful, brilliant Harvard professor who died terribly young. I wish she had lived longer and written more of these books to explain what she meant by tribunality, because she never really tells us. The book is teasing us with this concept of tribunality that she never properly defines anywhere, and I've gone through it so many times. But I think other people are onto this, but when you say this kind of thing, you're very unpopular with the lawyers, and the political scientists don't know what you're on about. So this is a space that I'm very comfortable in, making people feel uncomfortable with their disciplinary boundaries and their models and frameworks, but you don't have any friends. Once you start saying stuff like this, you're out in the wilderness intellectually. I guess that's where I am to some extent. Frank's looking like he might be my friend here. So. Yeah.
Yes, well, I'm going to say, Duncan, that you're certainly welcome among sociologists. I mean, we never dealt well with political scientists anyway. Anyway, so I'm ready for my comments. I would like to welcome everybody and echo Tyrell's hope that everybody is safe when they are speaking from the center of the pandemic. Myself in New York, I am safe, and I'm hoping everybody else is too. Duncan, thank you for inviting me to participate. And Tyrell, let me say, those were wonderful remarks. I found myself making lots of notes, and you stimulated lots of thoughts for my own work and questions for future conversations. So thank you very much. I'm going to be as brief as I can. Like any good lawyer, I wrote down some comments, so I'm going to use the text that I wrote. It's short, and I hope will be okay. I'm going to review some of the things that people have said before, but I think I'm approaching this from a slightly different angle as well. I want to say a little more fulsomely than Tyrell did, although I know that she feels this way, how readable this book is, and that everyone really should approach it. Don't pay any attention to Duncan's claim that it's long and boring. His exclusive interviews are the meat of this book. It's not a political science treatise. It's rich in content, but also in representation of variation within the elite group that he's talking about, an elite group that's often viewed as caste-like and insular and in lockstep. I'm going to say more about that in a minute, but the interviews are really only the beginning. The interviews are gracefully interwoven with background and contextual detail gathered over many years of study, and it's highly readable. I can't say that often enough. Descriptions of key cases read like a novel, and they dip into the lives of communities outside the courts, including one that I've been studying, that is Lawyers for the Rights of People. I think it goes without saying, and you've heard Tyrell say this, and Duncan really has pegged his career as a political scientist on this feature, that judges and legal systems really can't be separated from political institutions that legitimate and empower them. That's just by their very nature. What makes that a problematic statement is that Western observers, and particularly a lot of Western social scientists, seem the need of reminding this again and again when they're surprised by the differences in function
that defy expectations based on European-inspired formal similarities. And they're inclined to call these differences failures and sort of write it off. Let's try it again by writing another constitution. Indeed, the so-called failures often serve political functions unfamiliar, forgotten, or rendered conveniently invisible in global North democracies. And I think that's one of the major takeaways of this book, is that what we're seeing in the book happens in subtle ways many places, and in not so subtle ways other places too. So there's a unique feature, though, here in the story that Duncan's telling. Southeast Asian legal systems, typically operating within states with dominant executive branches and possessing limited independence, make this easy to see. Within that community of nations, judiciaries to varying degrees are subservient to politics. Singapore's control of judicial rotation and appointments. Pre-2010 Myanmar's system of direct intervention and influence over decision. Indonesia's endemic political corruption. In Malaysia, until recently, a one-party dominated political system gave executives an extraordinary degree of influence over the judiciary. Thailand almost seems like an exception. Duncan describes lifetime appointments with relatively good pay, relatively low levels of corruption, objective selection criteria, and high qualifications for office. What could be wrong? Much, and that's what the book's point is. Duncan shows us Thailand is the exception that proves the rule. He shows us judiciary thoroughly integrated into the foundations of state legitimacy, linking its own place to the monarchy and in turn preserving the monarchy above all in the most subtle of ways. Of course, there's much more. Bring somewhat different points of view, which is surprising from the objective selection criteria, and make a career there. He shows us how a combination of factors, self-selection, subtle reinforcements within a community of practice, and seductions of status contribute to perceptions and actions of the judiciary. The individual judge's background are different, but by mid-career, if not earlier, their perceptions and actions typically bend toward conservative institutional goals. Judiciary is anchored in continuing presence of the monarchy in a modern state. But of course, it isn't the judiciary alone. The judiciary, its authority linked to a particular kind of state, in turn legitimates the administrators who make state policy and carry it out. The function of judiciaries everywhere. So it would require many additional books, and I can just see that as Duncan gathers momentum here. The next one in the making, to elaborate the critical role of judiciary in the wider political and social system. But Duncan gives us more than a glimpse of the court's embedded influence through four in-depth case studies, which I think are really in some ways one of the strengths of the book. And if you don't read anything else, read those case studies. They're fun to read. They're incredibly insightful about what really goes on in the minds of the judges and in courtrooms. So I'd like to add this too about Duncan's approach to what he studies. Dan Lev, who's a renowned political scientist who spent a lifetime studying legal systems in Indonesia and other Southeast Asian countries, approached courts and judges assuming they were part of the political administrative apparatus, an apparatus with its own institutional and organizational rules, but derived from and dependent on the larger system nevertheless. And the resemblance between what Duncan's doing and what Lev is doing goes much farther. Duncan's approach reminds me of Lev's cultural analysis, where culture referred not to grand abstractions or generalities, but rather the way institutional functions are constructed through interactions between many role players, players whose perceptions of self or work and actions are mutually constituted. Lev went further in a lifetime of work on Indonesian courts, examining courts, the way they're interwoven with networks of officials, clerks, colleagues, litigants, political and legislative actors, and others. The culture of the judiciary was made up of this complex tapestry, and Duncan's book opens this door. I think it's a magnificent achievement, just as Lev's lifetime of work also was path-breaking and door-opening. One final point. Something that's really impressive and for me incredibly helpful and eye-opening is that we get a first glimpse of the ideological and personal differences among judges. They're often presented as caste-like, insular, and uniform in outlook. That just is not the truth. Duncan notes that there are red and yellow judges at every level, referring to the color-coded conflicts that began in the early 2000s. Duncan notes the sharp contrast in the roles of judges in the courts of justice, administrative courts, and constitutional courts. The latter sometimes viewed by the ordinary judiciary as no courts at all. So what effect does that have on the collegiality and outlook and interaction among members of the judiciary? He describes infighting and disagreement among judges in rendering decisions. Like the new diversity of the political landscape itself, disagreement may tell us something about change. What should we make of that, and where does that lead? There's a great deal of work to be done here, considering just the most important political cases decided by the Constitutional Court, a point that Tyrell made and one that Duncan clearly appreciates in the further work that he's doing here. The vast majority are not unanimous, even looking at just the Constitutional Court, are not unanimous, and some of the most important were close votes, as Duncan himself explains. What should we make of that, especially going forward? That's a tremendously under-analyzed, under-conceptualized, underutilized feature of these Constitutional Court cases. I mean, there's a controversy there waiting to happen, and other than an occasional voice from Nitirat, I don't see much actually being done with that diversity in the opinions themselves. Of course, above and beyond the outcome, it's also, these cases also have influence on jurisprudence and what kind of influence. Other countries, an echo chamber of commerce that keeps courts engaged with thinking outside the courtroom, yet only a handful of scholars in Thailand have taken this up. Lev's insights and Duncan's suggestive case studies lead us to consider the judiciary's not so harmonious interactions with other communities of practice in the changing landscape, the media, influential non-elites in business in the international world, social networks, and above all, groups promoting or resisting political and social change, which may be within the bureaucracy, they may be politicians, they may be lawyers and their clients. And what about that last? That is the influence of cases, litigants, and lawyers. They raise new issues that have not been well understood, and they present uncomfortable questions of interpretation of government authority, and Duncan's case studies illustrate that happening. They drive wedges in the judiciary. How far will the court go to fudge a decision? What are the consequences of fudging within the judiciary itself? Or the credibility of the court? What kind of impact? Lawyers have described to me educating judges about social conditions unfamiliar to them because of their relatively privileged, sheltered, and often worked and bored bureaucratic status. Where does that lead? How is the judiciary being changed from below, in a sense? Respectful advocates for new social causes stretch interpretations of statutory and constitutional provisions without invoking ideological conflict. But some lawyers imbued with the cause have abandoned the subordinate and respectful role customary in the judge-practitioner relationships. And Duncan describes, I mean, it would be hilarious if it were not so tragic, the parliamentary invasion case in which we find the Thai equivalent of the Chicago 8 trial in a Bangkok courtroom. Of course, the antics of the Chicago 8 and their attorneys far exceeded anything in Thailand, but the transformation that may be occurring in relationships between these dissenting lawyers and judges may be a bellwether of larger changes in politics. Nevertheless, in Duncan's narrative, the two tightly networked groups, these cause lawyers on one hand and judges on the other, are locked in opposition, unable or unwilling to communicate, leading to a bizarre trial and an unfortunate outcome for the defendants. Where does that go moving forward? Is that going to continue? Will the judiciary respond? Will attorneys find a new wedge into the courtroom? Can the judiciary change? How does it change? In particular, can social movements' claims for new rights of their lawyers make a difference? And when, echoing Tyrell, I think to a degree, when will it confront the military and under what conditions? Going back to what Duncan said, that his enemy is legalism. In some ways, sociologists have abandoned that a long time ago. Legalism is not the enemy. I do agree that speaking as a law school teacher, there's still a lot of faith, and that's a very American, hang up, I think, to believe in legalism. But it's also infected policies of the World Bank. Every agency that's affected by the Washington Consensus still hangs its hat on improving legal systems first. But as early as the 1970s, when Dan Lev wrote, he said, we've got to get beyond that. Let's just look at the evidence. It's just not the way the world functions. Let's move on and let's develop a richer, much better understanding of how the law works. So Duncan, I'm not sure if there are questions there to take away. There's certainly many book projects that I point to. I tried to integrate what you've done a bit with my own interests about change from below and whether there are avenues open for connecting the judiciary in new and different ways with a public that seems to be moving forward. We really haven't talked about that. The 2019 elections,
yes.
As I learned in detail at your 2019 Thailand update, have really stunned the political scene in Thailand. Maybe you could say a little about that and what you think the impact of that was.
Thanks very much for those really important and interesting points, Frank, and thanks for highlighting some of the things that I'm most eager to get across in the book that probably didn't come across in my own remarks or my responses just now. Yeah, I mean, look, the single biggest takeaway about the judges and the court cases is it's complicated. I don't believe in conspiracy theories. I don't believe in the deep state. And I've said it over and over again. I've written it in the book. I don't think everybody is on the same page. I don't think everybody is consistent. I don't think every Thai judge subscribes to the same basic ideas. And I don't think there's any mastermind telling them all what to do all of the time. I also think that the story keeps changing, and that just when you think you know what's going on, you realize again you've got no idea what's going on because the sand has shifted beneath your feet, and this is the problem. At a certain point, I had to cut off the book. I basically cut off the book around the end of 2016 for reasons that are logical. But I make some passing reference to what's happened since then at the end of the book, and clearly there have been very important court cases, not least, the dissolution on my birthday of the Future Forward Party, which is the focus of a book I'm trying to write now. I'm trying to write The Rise and Fall of the Future Forward Party, which I think is going to be, in some ways, a follow-up and in some ways a change of direction. And that book obviously is about, yes, where's the hope? There was a very, very interesting showing of support of more than 6 million voters for this upstart party, which had very clearly nailed its orange colors to the mast of resistance to the military and resistance to the status quo. And the solution is just to ban that party and dissolve it and hope that those people are going to go away. And that's clearly not going to work out very well because you've suppressed so much dissent and you've suppressed so much opportunity for dialogue. I mean, the Future Forward Party as a middle-ranking opposition party was posing no threat to the existing government. You'd think it would make a great deal of sense just to leave them in play so that you could say to everybody, the wider world as well as the domestic audience, look, we have these very oppositional people in our parliament. There's no problem. We'll just put up with them. But no, they couldn't be put up with. And that really is a worrying trend. And it's a worrying trend in a variety of ways. And both you and Tyrell sort of end by asking me what's going to happen in the future. And that's, of course, the terrifying question for anybody who works on Thailand, because we're struggling so much to understand what happened in the fairly recent past. We've no idea what's going on now, and we've not the slightest idea what's going to happen next week. But
fair enough.
What we do know is that it won't be exactly as it was before, that it won't be predictable. We are in a new reign. Things are being done differently from the way they were done in what we might call the classic network monarchy era, during which there was a lot more leeway granted because agency was more ambiguous. And now agency is less ambiguous. Instructions come from one clear direction. So things are going to happen in a different way from the way they happened before. But how that will play out in terms of future treason-related court cases remains far from clear, because again, even though we have a new system and it seems to be more clear-cut and more decisive, that doesn't mean that they, whoever they are, the monarchical network or whatever you want to call them, have really figured out how to play this stuff. I think they're still trying to work out the best way of operating and the most viable and sustainable and legitimate way of functioning in this variant on the old order, in which the judiciary plays a role, but I think probably has rather less agency than it did in the 2006-2016 period. That was my main focus in the book. Now I know we don't have that much time left for questions.
No, indeed.
A few of those.
Yes. So, well, thank you very much, both Tyrell and Frank, for your comments, and thanks, Duncan, for answering. So, thank you for our audience members for sending us a lot of questions. So, I'm just going to be able to only ask a few. So, I am going to start. We've got a question about why does your book focuses on virtue and not justice, and what's the difference about these two concepts in the Thai context?
Yeah, that's a really good question. Well, the phrase "fighting for virtue," it comes from one of the King's speeches delivered in April 2006, when he gave this kind of mandate to judges to help solve Thailand's political problems. So fighting for virtue is a phrase straight out of that speech. And of course, "let there be virtue" is a phrase that we read at the beginning of Thai constitution. So there's an idea of virtue as a starting point, where you would think in a democratic society you'd be beginning with other notions, like the people, like representation, like citizenship, like participation. But virtue is very, very often a starting point for a lot of discourse in the Thai political and judicial and legal context. But of course, it does start you off with a very different set of premises from if you're attempting to administer justice as understood in many other political systems. So that's why I focused on, it's very different. And one of the main agonies of the book, apart from writing it, was coming up with a title. And we went through, as usual, a dozen or so titles that all got rejected. And this is the one we finally settled on. So it's difficult to sum this up in its essence, but I thought the idea of fighting for virtue, the notion that Thai judges have and the people associated with the judicial system have, that they're trying to achieve good for the society, was a more accurate starting point than in a way using the word justice before the colon.
Thank you. There was another very interesting question from one of our audience members, and it was about the recent suicide of one of Thailand's judges.
Yes.
And the question is, do you think that will this suicide actually spark a conversation of reform in Thai judicial system? And if so, do you think it can potentially have any long-term ramifications?
I mean, it's very hard to know, and I haven't been in Thailand since the couple of incidents and the very, very unfortunate suicide of the judge took place. And I haven't been able to do the kind of thing that I would like to do, which is to read more deeply and talk to people who are familiar with the situation. But I think that episode, and I'm not in a position to comment on the particular court cases and the specific allegations that the judge made, but the basic issue that there's a problem about how some court cases are decided, and that some judges feel uncomfortable with what they perceive as instructions or pressures that are placed upon them, and that they're also operating within a framework of pretty draconian punitive options. They don't have a lot of discretion. Well, if they've decided someone's guilty, then there's a fairly narrow range of options facing them. And these link very much to the issues that I talk about in the book in terms of the socialization of judges, and they link back to the problem of tribunality. Sometimes judges need to be able to exercise more discretion, and they feel frustrated that they're not able to exercise that discretion. And sadly, in this case, that frustration seems to have reached a particular peak. I would hope that case and that more public discussion and reflection on some of these issues would stimulate more discussion about reform. I mean, the difficulty is that it's a closed system. The judges themselves are ridiculously overworked. There are a staggering number of court cases, and they barely have time to collect their thoughts. Even the Supreme Court judges, who ought to be in a role of stepping back from the fray and thinking strategically and in the long term about how to improve things, they're very incredibly caught up in day-to-day routine work that they never manage to clear. And there's nobody who's really tasked with the role of thinking about these bigger questions of how to reform the judiciary. So part of the problem is that the judiciary is very proud of its independence, and no longer is there any political oversight from the Ministry of Justice or from any other agency outside the judiciary. On one level, that might be good because it removes certain kinds of interference, but it also means there's nobody to perform the function of a sounding board or a critical voice to advance these things. So judges themselves are left to regulate themselves and to try and deal with problems that they don't have a lot of time or energy to think about, and they're often not very well positioned to think about. They need somebody who's a little bit removed from the fray of the situation to help. So it's not a very good setup for reform, and that's one of the problems, one of the reasons why things that should have been changed a long time ago, like the very ossified transcription system where judges spend a lot of time in court taking notes at a much more mundane level. All sorts of things everybody agrees don't really work, but nobody can figure out how to change them. And that's a problem with any institution. And it's a problem with many, of course, many judiciaries and many institutions around the world, not at all unique to the Thai judiciary, but the lack of mechanisms to talk about how to improve things is a real problem.
There's also one very interesting question that just popped up from the audience. Is there any sort of internal ideological policing within the Thai judiciary? And if so, could you maybe elaborate briefly what form it takes?
Well, as Frank pointed out, and as I talk about in the book, there are judges of all kinds of ideological persuasions. It's not that all judges come out of the same cookie cutter, classic yellow, to use what's become an increasingly simplistic and crude term, because we're sort of beyond yellow and red while still being stuck with them. There are judges who have very different kinds of political ideas. Nevertheless, I think what's disappointing is there's not much of a forum, as far as I can see, inside the judiciary for people to have conversations about the way they understand politics, law, and justice, and how those things interact. So even though there may be a diversity of views, there's not very much opportunity for those diversities to be played out. Thai judges have a kind of understanding of who the judges are, who have slightly more critical views of the situation. Some of those judges sort of know each other, but it's not like there's a clear-cut ideological divide. It's all out in the open, and people sit around in seminars and talking about how should we really be handling these lèse-majesté cases, or how should we be dealing with this problem of people not being let out on bail. There isn't nearly enough of that kind of conversation going on, even when the ideological range may actually be there. There isn't really a forum for it to be tapped into.
Duncan, could I add a footnote here too to what you say, which is very much in line with what you're saying? In a recent round of interviews I did just in January and February before I got myself out of there, I talked with two judges, both you would call them reforming judges. And what they've done, I mean, one of them's young, one of them's sort of mid-career, but they both made a reputation as quote unquote NGO types. They found administrative posts. That is, they're in a central, office doing administrative tasks, one of them kind of interacting with foreign
all these kind of alternative
foreign judiciaries, and the other one is sort of involved in policy in a certain area. So they've taken themselves out of the fray where these things are an issue. And of course, they've also, unless they tend to publish and get slaughtered or whatever happens when you go public with your views, they're not interacting with judges on the bench, or with their technical supervisors, with their official bureaucratic supervisors.
Right.
At any rate, so there's that happens too.
Yeah, there are sort of alternative judicial careers, but they don't really help to, as much as you'd think, to open up a discussion between people with different perspectives. Yeah.
I guess we could quickly manage one more question. So we started off with sort of broader conceptual questions, so I'll ask the last one that is, again, on the conceptual side. in international relations, there is a concept of lawfare, so law as a
yes,
where law is used for strategic means.
right.
The question basically from the audience is solution to legalism a more honest use of lawfare as a concept?
Sorry, is what to legalism?
Is solution to legalism a more honest use of lawfare?
All right, so people would stop pretending that they were actually just using law and say, this is basically a war by other means, and we're using the law as a political tool. So people should just kind of fess up to their politicization and their weaponization of law. Yeah, I mean that's one way of looking at it. I think it would be a shame. I mean, lawfare is really that, you know, people have used that term in the context of recent court decisions in Thailand, and clearly in invoking that term, they're attempting to discredit the behavior of those people. So it would be slightly perverse to try to argue that lawfare would be, you know, a legitimate way of conducting political and judicial business. But you could see some people, you know, might want to go down that sort of road. Yes.
Right. I think we've run out of time for today. So I would like to thank once again to all our three distinguished speakers. So thank you, Duncan, Tyrell and Frank, for your inputs and for the very interesting discussion of Duncan's latest book. Is there anything, Duncan, you would want to say as a sort of closing remark about your book?
Well, I'd like to say thank you very much to everybody who's been involved in this, to Tyrell and Frank for their wonderful comments, for you, Petra, for moderating this, for Anna and Adela, the Nordic Institute of Asian Studies staff, and Srini with New York Southeast Asia Network. And this has been a big experiment. Sorry we couldn't get in more questions. It's just in the nature of this format. But no, this has been wonderful. I hope some people will read the book. As I say, I'm not asking you to read all of it. Just dip in and read a few pages, because I think it's a little bit long, but our two commentators have actually said it is worth reading from beginning to end, which is very nice of them. And I'll be paying them handsomely later for that. But yeah, as both Tyrell and Frank said, we hope that everybody stays safe and well in these difficult times, and that we can look forward to moments of liminality, if not luminosity, that will help us to get through these dark days of COVID-19, but also perhaps to find better ways of managing the complicated relationship between justice and politics, not just in Thailand, but in many other places around the world. So thank you so much.
Well, thank you very much. And I think I would just like to add one more thing, that keep an eye out on NIAS's website and Facebook as well. There might be more online events and podcasts that will be available soon for those of you who are interested, not just in Thailand, but other Asian countries and study of them. So if you want to learn more, do keep an eye out.
And we'll be uploading the recording of this event.
Yes.
So you can watch it at home later.
Thank you.
Thanks a lot.
Thank you. Bye.